Question 1. Consumer privacy and data protection. During a comprehensive review of a process that needs improvement, a large online retailer discovers that its user data collection policies may not be fully compliant with privacy laws. The company collects consumer information, including purchase history, browsing habits, and financial details, and shares this data with third-party advertisers without explicit consumer consent. Which of the following legal frameworks most directly governs consumer rights in this scenario? A. The Fair Debt Collection Practices Act FDEA. B. The Gramm-Leach-Bliley Act GLBA. C. The Federal Trade Commission Act FDEA. D. The Truth in Lending Act TILA. Answer. B. The Gramm-Leach-Bliley Act GLBA. Explanation. The Gramm-Leach-Bliley Act GLBA primarily governs how financial institutions handle consumer data. While the retailer in this scenario is not a financial institution, the GLBA establishes privacy and disclosure requirements for businesses that collect and share consumer financial information. The law requires institutions to inform consumers about their data sharing practices, to provide an opt-out mechanism to prevent unauthorized sharing. Incorrect answers. A. DEA applies to debt collection practices and does not regulate consumer data privacy. C. FDA addresses deceptive trade practices but does not focus specifically on data sharing laws. However, the Federal Trade Commission (FTC) can enforce privacy violations under this act. D. TILA focuses on transparency in credit transactions, not on privacy. The retailer should update its privacy policies to comply with DBA by implementing a clear opt-in consent mechanism and ensuring transparency in data sharing practices. Additionally, it should align with other laws like the General Data Protection Regulation (GDPR) if handling EU consumer data. Question 2. Unfair and deceptive trade practices. While analyzing the root causes of sequential problems in a nationwide consumer electronics store, the Federal Trade Commission (FTC) discovers that the store has been using bait-and-switch tactics to increase sales. Customers are drawn in by advertisements for high-end televisions at discounted prices, but upon arrival, they are pressured to purchase more expensive models under the pretense that advertised product is sold out. Which of the following laws best addresses this deceptive practice? A. The Consumer Product Safety Act (CSA). B. The Magnuson-Moss Warranty Act. C. The Federal Trade Commission Act (FTCA). D. The Fair Credit Reporting Act of CRA. Answer. C. The Federal Trade Commission Act (FDA). Explanation. The Federal Trade Commission Act (FDA) prohibits unfair or deceptive trade practices, including false advertising and bait-and-switch schemes. Bait-and-switch occurs when a business advertises a product at an attractive price but never intends to sell it, instead redirecting consumers to more expensive options. Under Section 5 of the FTCA, such deceptive practices can lead to enforcement actions by the FTC, including fines, corrective advertising mandates, and cease and desist orders. Incorrect answers. CSA relates to consumer product safety and does not regulate advertising practices. B. Magnuson-Moss Warranty Act deals with warranty protections, not deceptive advertising. D. CRA regulates credit reporting and financial data, not sales tactics. To comply with FDA, businesses must ensure honest advertising and disclose product availability accurately to consumers. Question 3. Consumer contracts and legal protections. When implementing new protocols in a shared environment, an online subscription service modifies its terms of service (TOS) to include a mandatory arbitration clause preventing customers from filing lawsuits or joining class action lawsuits. The company does not notify existing users about this change and requires all new users to agree before proceeding with their subscription. If a dispute arises, which legal principle is most relevant in determining whether the arbitration clause is enforceable? A. The principle of unconscionability in contract law. B. The doctrine of caveat emptor. C. The Magnuson-Moss Warranty Act. D. The Fair Credit Billing Act (FEB). Answer. A. The principle of unconscionability in contract law. Explanation. The principle of unconscionability refers to contract terms that are so one-sided or unfair that they shock the conscience and may be ruled unenforceable in court. In this case, the arbitration clause may be considered procedurally unconscionable if consumers were not given proper notice and had no real opportunity to negotiate. Additionally, if the clause heavily favors the company, stripping consumers of fundamental legal rights, it may also be deemed substantively unconscionable. Incorrect answers. B. Caveat emptor. Let the buyer beware. is a principle in contract law but does not apply when unfair or deceptive clauses are hidden in agreements. C. The Magnusson Warranty Act applies to product warranties, not arbitration agreements. D. The FABA deals with credit billing disputes, not contract fairness. With contract law principles, companies should provide clear disclosure, allow opt-out mechanisms, and ensure arbitration clauses are fair and mutual to avoid legal challenges. Question 4. In a high-stakes environment where multiple challenges intersect, a manufacturer of home appliances advertises a new refrigerator model as energy efficient and claims it can reduce electricity bills by up to 30%. However, independent consumer tests reveal that the actual energy savings are only around 10%, significantly lower than advertised. A group of consumers files a lawsuit under the Federal Trade Commission, FDA, claiming that the company engaged in deceptive advertising. Which of the following is the most accurate legal consequence the company might face? A. The company is automatically required to refund all consumers who purchased the refrigerator, regardless of whether they relied on the advertisement. B. The company may be subject to a Federal Trade Commission (FTC) investigation, which can lead to penalties, corrective advertising, and an injunction against further misleading claims. C. The company is protected under commercial free speech rights and cannot be penalized unless the consumer can financial harm. D. The consumers must first prove that the manufacturer deliberately falsified the energy efficiency claims before any legal action can proceed. Answer. B. The Federal Trade Commission Act (FTA) prohibits unfair or deceptive acts or practices in commerce, including false advertising. The FTC has the authority to investigate companies that mislead consumers and can impose penalties such as fines, corrective advertising requirements, and injunctions. Explanation. YA is incorrect. Refunds are not automatic. Consumers typically need to demonstrate reliance on the false claim and find harm to seek restitution. YC is incorrect. While commercial speech is protected under the First Amendment, deceptive commercial speech is not. Misleading advertising is regulated. YD is incorrect. The FTC does not require proof of intent to deceive, only that the advertising is likely to mislead consumers. Question 5. While investigating a complicated issue between different stakeholders, a financial institution is accused of violating the Fair Credit Reporting Act of CRA by failing to properly investigate a consumer dispute regarding inaccurate credit report information. The consumer claims that despite submitting evidence of an error, the institution refused to correct the mistake, leading to a low credit score and a denial of a mortgage loan. Of the following best describes the financial institution's obligations under the FCRA? A. The institution must investigate the consumer's dispute within 30 days, correct any errors, and notify the consumer. B. The institution has no obligation to correct errors unless the consumer provides court order proving the inaccuracy. C. The institution may take up to 90 days to investigate and respond to consumer disputes regarding credit report inaccuracies. D. The institution is only required to investigate disputes originate from credit bureaus, not individual consumers. Answer. A. Under the Fair Credit Reporting Act of CRA, when a consumer disputes an error in their credit report, the financial institution, also known as a furnisher, must investigate the claim within 30 days, and if the information is inaccurate, correct it. Explanation. Why B is incorrect. A court order is not required for the financial institution to investigate and correct an error. Why C is incorrect. The FCRA sets a strict 30 timeline, not 90 days. Why D is incorrect. The law requires institutions to investigate disputes initiated by both consumers and credit bureaus. Question 6. During a comprehensive review of a process that needs improvement, a consumer advocacy group discovers that an online retailer has been charging undisclosed fees at checkout which were not mentioned in the advertised price of the product. This practice has led to consumer complaints under state unfair and deceptive trade practices laws. What legal principle is most applicable in this case? A. The retailer may be violating bait and switch laws by advertising a low price and adding fees at checkout. B. The retailer is not liable because consumers have the choice to review fees before finalizing the purchase. C. The practice is only illegal if consumers can prove they were forced to complete the purchase despite the additional fees. D. Since the fees were displayed on the final checkout page, the retailer is in compliance with all advertising. Answer. A. The bait and switch doctrine prohibits misleading pricing tactics, including advertising a low price and adding undisclosed fees at checkout. Explanation. Why B is incorrect. Transparency in pricing is required before purchase. Hidden fees violate consumer protection laws. Why C is incorrect. Consumers do not need to prove coercion, only that the practice is deceptive. Why D is incorrect. Checkout disclosure is insufficient if the initial advertising was misleading. Question 7. When implementing new protocols in a shared environment, a landlord in a rent control building begins charging tenants an additional administrative fee for building maintenance. Tenants argue that this new charge is illegal under rent control laws and file a complaint with the local housing authority. Which legal principle is most relevant to this dispute? A. Landlords cannot impose new fees not explicitly listed in the lease under rent stabilization laws. B. Landlords can introduce new fees at any time as long as they provide 30 days notice. C. The charge is valid because maintenance fees are necessary for property upkeep. D. The tenants must first prove financial hardship before the charge can be challenged. Answer A. Rent stabilization laws prohibit landlords from introducing new fees beyond those agreed upon in the lease. Explanation why B is incorrect. Even with notice, unauthorized fees violate rent control regulations. Why C is incorrect. Property maintenance costs are already factored into rent control pricing. Why D is incorrect. Financial hardship is irrelevant if the fee itself is illegal. Question 8. When dealing with a complex system that shows occasional failures, a financial services company updates its online payment system. However, customers report that unauthorized transactions have been processed due to an issue with how the system saves payment details. The company argues that these transactions were approved by customers, but an investigation shows that the system retained expired approvals from past sessions. Which of the following protection laws is most applicable to this case? A. The Electronic Fund Transfer Act (EFTA), which protects consumers from unauthorized electronic transactions. B. The Truth in Lending Act (TILA), which governs fair credit billing and loan disclosures. C. The Fair Debt Collection Practices Act (EA), which regulates debt collection methods. D. The Fair Credit Reporting Act (FCRA), which concerns credit reporting agencies and disputes. Answer A. The Electronic Fund Transfer Act (EFTA) protects consumers from unauthorized electronic transactions, including errors caused by system malfunctions. Explanation why B is incorrect. TILA deals with loan disclosures, not electronic transaction failures. Why C is incorrect. That EA applies to debt collection agencies, not payment processing errors. Why D is incorrect. The FCRA regulates credit report accuracy, online payments. Question 9. During a critical transition period where existing processes are being restructured, a landlord in a rent-controlled apartment building begins requiring tenants to sign new leases with higher security deposits and a mandatory insurance policy. Several tenants claim this violates state rent control laws and refuse to sign. Which legal principle best applies in this situation? A. Landlords cannot impose new lease conditions that circumvent rent control protections. B. Landlords may modify lease agreements at will as long as they give 60 days notice. C. Tenants must accept new terms if they wish to remain in the property. D. The new lease is valid if at least 50% of tenants agree to it. Answer A. Many state rent control laws prohibit landlords from adding fees or conditions that act as factor rent increases. Explanation why B is incorrect. Even with notice, illegal lease terms remain unenforceable. Why C is incorrect. Tenants under rent control cannot be forced to accept changes outside the law. Why D is incorrect. Individual lease agreements are binding regardless of a tenant majority. Question 10. While investigating a complicated issue between different consumer groups, a major auto manufacturer is sued for misleading advertising after claiming that a new vehicle model has a higher fuel efficiency rating than what real-world tests indicate. What is the most likely legal consequence? A. The manufacturer could face Federal Trade Commission (FTC) penalties for deceptive advertising. B. The manufacturer must immediately refund all customers, regardless of whether they relied on the claim. C. The advertising is protected under commercial free speech and no action can be taken. D. The manufacturer is only liable if it can be proven that the claim was made with intent to deceive. Answer A. The FTC Act prohibits false or misleading advertising. Companies can face fines and be required to run corrective ads. Explanation why B is incorrect. Refunds are not automatic. Consumers must typically demonstrate reliance. Why C is incorrect. Deceptive advertising is not protected under free speech laws. Why D is incorrect. Intent is not required, or only that the claim is misleading. Question 11. In an environment where different components must interact efficiently, a credit card company issues new reward terms without notifying existing cardholders. As a result, many customers unknowingly lose accumulated points, which regulation has likely been violated. A. The Truth in Lending Act, TILA, which requires financial institutions to disclose key terms. B. The Fair Credit Reporting Act, FCRA, which deals with credit report accuracy. C. The Consumer Leasing Act, CLA, which applies to rental agreements. D. The Equal Credit Opportunity Act, ECOA, which prohibits credit discrimination. Answer: A. TILA ensures that credit issuers disclose important account changes, including rewards modifications. Explanation: why B is incorrect. FCRA covers credit reporting, not credit card policies. Why C is incorrect. The CLA applies to leases, not credit card terms. Why D is incorrect. ECO covers discrimination in credit decisions, not reward programs. Question 12. During an emergency response where multiple areas are impacted, a state declares a price gouging law after a hurricane. A retailer is found selling bottled water for 10 times the usual price. What is the most likely consequence? A. The retailer may face fines and penalties for violating anti-gouging laws. B. The retailer can legally charge any price it wants as long as customers agree. C. Price gouging laws only apply if all businesses in an area raise prices. D. The law does not apply to essential goods like water. Answer: A. Many states prohibit price gouging during emergencies. Explanation: why B is incorrect. Businesses cannot take unfair advantage of disaster conditions. Why C is incorrect. Laws apply even if one retailer raises prices excessively. Why D is incorrect. Essential goods are specifically protected. Question 13. When implementing new protocols in a shared environment, a large healthcare provider updates its patient data system. However, multiple physicians report inconsistent medical records, causing errors in treatment plans. Which regulation is most applicable to resolving this issue? A. The Health Insurance Portability and Accountability Act, HIPAA, which mandates patient data security and accuracy. B. The Fair Credit Reporting Act, FCRA, which governs financial data accuracy. C. The Americans with Disabilities Act, ADA, which protects individuals with disabilities. D. The Federal Trade Commission Act, FTC Act, which prohibits deceptive business practices. Answer: A. HIPAA requires accurate, secure handling of medical records to prevent errors. Explanation: why B is incorrect. FCRA governs credit reports, not health records. Why C is incorrect. ADA ensures equal access, not data integrity. Why D is incorrect. The FTC Act covers misleading business practices, not medical record management. Question 14. During a comprehensive review of a process that needs improvement, a manufacturing company finds that certain workplace safety procedures are outdated. Employees report increased injuries, but management has not updated its Occupational Safety and Health Administration (OSHA) compliance procedures. What legal risk does the company face? A. Fines and penalties for violating OSHA regulations. B. No legal consequences since safety updates are voluntary. C. Only liability if an injury directly results from outdated policies. D. Potential tax deductions for implementing new safety measures. Answer: A. Employers must comply with OSHA regulations to maintain worker safety. Explanation: why B is incorrect. OSHA standards are mandatory, not optional. Why C is incorrect. OSHA violations do not require an injury to be enforceable. Why D is incorrect. Tax deductions are irrelevant to compliance obligations. Question 15. While analyzing the root causes of sequential problems in its system, a company discovers that an employee data breach occurred due to outdated cybersecurity software. Employees file a lawsuit citing privacy violations. Which law is most relevant? A. The General Data Protection Regulation (GDPR), which applies mainly to European data. B. The California Consumer Privacy Act (CPA), which enhances privacy rights for California residents. C. The Sherman Antitrust Act, which prevents monopolies. D. The Fair Housing Act, which applies to property discrimination. Answer: B. The CPA grants California residents control over their personal data, including breaches. Explanation: why A is incorrect. GDPR applies to EU citizens, not US employees. Why C is incorrect. The Sherman Act addresses monopolies, not privacy violations. Why D is incorrect. The Fair Housing Act covers housing discrimination, not cybersecurity. Question 16. In a multi-location scenario where consistency requirements are critical, a fast food franchise struggles with maintaining standardized food safety protocols. Health inspectors find violations in multiple locations. What regulatory body is responsible for enforcing food safety laws? A. The Food and Drug Administration, FDA, which oversees national food safety standards. B. The Consumer Financial Protection Bureau, CAB, which governs financial transactions. C. The Department of Transportation, which regulates transportation safety. D. The Federal Reserve, which manages banking policies. Answer A. The FDA enforces federal food safety laws, ensuring uniform standards across locations. Explanation why B is incorrect. The CAB regulates financial issues, not food safety. Why C is incorrect. The DOC covers transportation safety, not restaurants. Why D is incorrect. The Federal Reserve deals with monetary policies, not food safety. Question 17. When improving a process that shows unexpected results, an airline company implements dynamic ticket pricing, causing customers to complain about inconsistent pricing. Which legal principle applies? A. Airlines can legally use dynamic pricing as long as it is not deceptive. B. Customers are entitled to the lowest price available. C. Airlines must charge the same price for all tickets. D. The Department of Justice must approve all price changes. Answer A. Airlines may legally adjust pricing, but cannot deceive customers. Explanation why B is incorrect. Customers are not guaranteed the lowest price. Why C is incorrect. Ticket prices are based on demand, not uniform pricing. Why D is incorrect. The DOJ does not regulate airline pricing unless antitrust concerns arise. Question 18. During a major transformation where existing methods are being replaced, a university introduces mandatory biometric attendance tracking for students. Some students refuse, citing privacy concerns. Which law is most relevant? A. The Biometric Information Privacy Act, BIPA, which regulates biometric data use. B. The Freedom of Information Act, FOIA, which applies to government records. C. The Gramm-Leach-Bliley Act, GLBA, which governs financial institutions. D. The Equal Employment Opportunity Act, which applies to hiring discrimination. Answer A. BIPA requires informed consent for collecting biometric data. Explanation why B is incorrect. FOIA applies to public records requests, not privacy rights. Why C is incorrect. GBA governs financial data, not biometric tracking. Why D is incorrect. EO laws do not cover student privacy. Question 19. In a high-stakes environment where multiple challenges exist, a large investment firm is accused of using insider trading to manipulate stock prices. Which law is most applicable? A. The Securities Exchange Act of 1934, which prohibits insider trading. B. The Consumer Protection Act, which governs product safety. C. The Patent Act, which covers intellectual property. D. The Clean Air Act, which regulates emissions. Answer A. The Securities Exchange Act prohibits using confidential information for trading. Explanation why B is incorrect. Consumer laws apply to products, not stocks. Why C is incorrect. The Patent Act governs inventions, not financial crimes. Why D is incorrect. The Clean Air Act regulates pollution, not securities fraud. Question 20. When dealing with a complex system that shows occasional failures, a hospital's automated prescription system sometimes delivers incorrect dosages due to software errors. Which legal or regulatory framework is most applicable? A. The Food, Drug and Cosmetic Act, FDA, which ensures drug safety. B. The Federal Trade Commission Act, FTA, which covers false advertising. C. The Fair Debt Collection Practices Act, FDEA, which regulates debt collection. D. The Sherman Antitrust Act, which prevents monopolies. Answer A. The FDA regulates drugs and medical devices, including software errors in prescription systems. Explanation why B is incorrect. The FDA applies to business deception, not drug safety. Why C is incorrect. The SDEA covers debt collection, not medical technology. Why D is incorrect. The Sherman Act addresses market competition, not prescription errors. Question 21. During a critical transition period where existing processes are being replaced, a large retail chain upgrades its customer database system but loses thousands of customer records in the process. Which legal consequence is most likely? A. A violation of the Gramm-Leach-Bliley Act, GBA, which protects financial data. B. A fine under the Federal Insecticide, Fungicide and Rodenticide Act, FIFRA. C. A penalty under the Endangered Species Act, ESSA. D. No legal action, as customer databases are not regulated. Answer A. The GBA requires companies to protect customer financial information. Explanation why B is incorrect. FIFRA governs pesticides, not data security. Why C is incorrect. ESA relates to wildlife conservation, not customer records. Why D is incorrect. Data protection laws apply, making no legal action an incorrect answer. Question 22. In a high-stakes environment where multiple challenges arise, an airline experiences repeated flight cancellations due to crew shortages but fails to compensate customers. Which law or agency is responsible for enforcing consumer protection in this case? A. The Department of Transportation, which regulates airline policies. B. The Federal Communications Commission, FCC, which regulates telecommunications. C. The Occupational Safety and Health Administration, OSHA, which oversees workplace safety. D. The U.S. Food and Drug Administration, FDA, which regulates food and drugs. Answer A. The enforces airline passenger rights, including refunds for cancellations. Explanation why B is incorrect. The FCC regulates telecommunications, not airlines. Why C is incorrect. OSHA focuses on workplace safety, not flight cancellations. Why D is incorrect. The FDA covers food safety, not airline policies. Question 23. When implementing backup procedures across various locations, a banking institution establishes redundant data centers to protect against cyber attacks. Which law requires financial institutions to have cybersecurity measures? A. The Bank Secrecy Act, BSA, which requires financial transparency. B. The Gramm-Leach-Bliley Act, GLBA, which mandates financial data security. C. The Federal Aviation Administration, FAA Act, which regulates air travel. D. The Equal Credit Opportunity Act, ECO, which prevents lending discrimination. Answer B. The GBA requires banks to protect customer data and establish backup systems. Explanation why A is incorrect. The BSA focuses on money laundering, not cybersecurity. Why C is incorrect. The FAR governs aviation, not banking. Why D is incorrect. The ECO addresses credit discrimination, not cybersecurity. Question 24. In an environment where different components must interact seamlessly, a logistics company faces supply chain disruptions due to inconsistent tracking systems across its warehouses. Which regulation governs international supply chain tracking? A. The Customs Trade Partnership Against Terrorism, CTPAT. B. The Truth in Lending Act, TILA. C. The Children's Online Privacy Protection Act, COPPA. D. The Health Insurance Portability and Accountability Act, HIPAA. Answer A. The CEPAT ensures secure and efficient supply chains. Explanation why B is incorrect. TILA covers loan transparency, not logistics. Why C is incorrect. COPPA protects children's online data, not supply chains. Why D is incorrect. HIPAA regulates medical data, not logistics. Question 25. While investigating a complicated issue between different departments, an automobile manufacturer discovers that its marketing team falsely advertised a vehicle's safety rating. Which legal issue is most relevant? A. False advertising under the Federal Trade Commission, FTC Act. B. OSHA violations related to workplace safety. C. Intellectual property theft under the Copyright Act. D. Antitrust violations under the Clayton Act. Answer A. The FTC Act prohibits deceptive advertising. Explanation why B is incorrect. OSHA covers worker safety, not advertising. Why C is incorrect. Copyright law protects intellectual property, not false claims. Why D is incorrect. Clayton Act prevents monopolies, not deceptive ads. Question 26. During an emergency response where multiple areas are impacted, a chemical plant releases toxic substances due to a storage tank failure. Which law regulates hazardous material incidents? A. The Resource Conservation and Recovery Act, or B. The Sarbanes-Oxley Act, SOX. C. The Electronic Communications Privacy Act, ECPA. D. The Fair Credit Reporting Act of CROI. Answer A. The RI regulates hazardous waste management. Explanation why B is incorrect. SOX deals with corporate fraud, not toxic spills. Why C is incorrect. ECPA governs electronic privacy, not chemicals. Why D is incorrect. FCRA covers credit reporting, not hazardous materials. Question 27. While analyzing the root causes of sequential problems in a large e-commerce company, the department discovers that delayed order processing results from multiple third-party payment system failures. Which federal law primarily governs electronic financial transactions and ensures consumer protection in such cases? A. The Electronic Fund Transfer Act (EFTA), which protects consumers in electronic payments. B. The Foreign Corrupt Practices Act (FEPA), which prevents bribery in international business. C. The McCarran-Ferguson Act, which regulates the insurance industry. D. The Consumer Product Safety Act (CSA), which governs physical product safety. Answer A. The EFTA ensures fairness and security in electronic payments, including third-party payment processing. Explanation why B is incorrect. FEPA deals with anti-bribery laws, not payment processing. Why C is incorrect. The McCarran-Ferguson Act regulates insurance, not commerce payments. Why D is incorrect. The CSA ensures product safety, not financial transactions. Question 28. In a situation where formal requirements conflict with practical needs, a government contractor working on infrastructure projects struggles to meet strict environmental regulations while ensuring efficient construction. Which legal doctrine or regulation allows for exceptions in such cases? A. The National Environmental Policy Act (NEPA), which mandates environmental reviews. B. The Dodd-Frank Act, which regulates financial institutions. C. The Lanham Act, which governs trademarks. D. The Telecommunications Act of 1996, which deregulated media industries. Answer A. The NEPA allows for environmental impact assessments and can grant exceptions or modifications when necessary. Explanation why B is incorrect. Dodd-Frank governs financial regulations, not construction projects. Why C is incorrect. The Lanham Act regulates trademark laws, not infrastructure. Why D is incorrect. The Telecommunications Act is unrelated to environmental concerns. Question 29. When scaling up operations that experience significant inefficiencies, a fast-growing tech startup faces supply chain disruptions due to poor vendor agreements. Which legal framework should guide the company in improving contract terms with suppliers? A. The Uniform Commercial Code, which standardizes commercial contracts. B. The Occupational Safety and Health Act (OSHA), which ensures workplace safety. C. The Glass-Steagall Act, which separates commercial and investment banking. D. The Fair Labor Standards Act (FLSA), which regulates employee wages. Answer A. The Act governs commercial transactions, including vendor agreements and supply chain contracts. Explanation why B is incorrect. OSHA focuses on workplace safety, not business contracts. Why C is incorrect. The Glass-Steagall Act affects banking regulations, not supply chains. Why D is incorrect. The FLSA covers labor laws, not vendor relationships. Question 30. During a seamless transition where continuity must be maintained, a healthcare provider migrates patient medical records to a new electronic health system, but data loss occurs in the process. Which regulation requires strict data protection for medical records? A. The Health Insurance Portability and Accountability Act (HIPAA). B. The Truth in Lending Act (TILA), which governs financial loans. C. The Sherman Antitrust Act, which prevents monopolies. D. The Federal Communications Commission (FEC), which regulates telecommunications. Answer A. HIPAA enforces strict security for electronic medical records. Explanation why B is incorrect. TILA regulates loan agreements, not healthcare data. Why C is incorrect. The Sherman Act prevents monopolies, not data breaches. Why D is incorrect. The FCC Act covers telecommunications, not medical records.